So you said you touched her and she didn't. Where did you touch her?
More so like the waist.
All right. And you didn't have her permission to do that?
No.
Okay. And you did that intentionally?
No.
You didn't touch her intentionally. He's asking if you touched her intentionally, like it wasn't an accident, like you touched her.
Like it wasn't an accident.
Like you touched her.
Like on purpose.
Like yes.
So yeah.
Yes.
Okay. Yes.
Okay. I'll ask the question again. Did you intentionally touch her when you said you touched her on the waist?
Okay. Yes.
You did? Okay. And that was without her consent, as we've established.
Correct.
And what is her relationship to you?
Right now? Or nothing?
It's probably not good right now, but what was it at the time?
I'll say dating. Yeah.
I'll say dating.
Yeah, because we wasn't.
What was your relationship with her?
We wasn't boyfriend girlfriend, so I'll say dating. We were intimate. I don't know.
Okay, that works. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and your time of sentencing, that the court would no longer be bound by any sentence agreement or evaluation of your case. You understand that?
Yes.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Which have led to this plea.
No, Your Honor.
All right. And have the court complied with the court ruling, would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Judge.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond in this matter with its conditions will continue. Thank you, sir. You can stop by probation on your way out the hallway. They'll be on your left.
Okay.
All right. Thank you. Court does call the case People versus Samira. Is it Takora?
Alexander on behalf of the people. Assistant Public Defender Natalie Pay on behalf of Ms. Takora, who I do not know or if she's present, Your Honor. I have had, oh, perfect, she's here. Let's talk on the phone. Ms. Takora, I apologize. Please state your name for the record. Samira Takora.
Thank you.
Sorry, at this time, people are unable to. Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am.
Thank you, Your Honor.
Court does call the case of the People versus Nicholas Stimmel.
That's false for people. And good morning, Your Honor. For the record.
Yep.
Good morning, Your Honor. For the record, Rita Young, appearing on behalf of Mr. Nicholas Stimmel, who is present standing to my right. Sir, would you state your name for the judge?
Nicholas Stimmel.
Thank you. I thought since you hadn't been here in so long, you just forgot where to stand.
Kind of.
It is good seeing you.
Likewise, Your Honor.
All right. I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of assault and or assault and battery, the 93-day offense. Upon his successful plea that's pleading as charged, there is an agreement as to sentencing that a prosecutor's deferred sentence with probation would be the sentencing case.
That is completely correct recitation of our agreement.
And Your Honor, it's my understanding that if successfully complete probation, the case will be dismissed.
That's right.
That is part of the prosecutor's deferred. That's correct. All right. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give the truth and nothing but the truth of you got.
Yes, I do.
Lower your hand and state your name.
Nicholas Stimmel.
Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still, basis for the no contest plea?
Civil liability,
All
possible.
right. Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
And well, I won't ask the last question. The court has been provided Pittsfield Township Department of Public Safety report for their case number 24-16014. Any objection to the court having reviewed that report?
None from the people.
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, after I accept your plea in between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would, any sentence evaluation or recommendation to the court would no longer be bound by. You understand that?
I understand that, Your Honor.
And you also understand that you would not at that time also be allowed to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
None, Your Honor, and it sounds like the court's not amenable to immediate sentencing.
I wasn't asked, but
Oh, okay.
by being asked, no. All right.
Yes, sir.
You just don't want to come back here, do you? You're just trying to make it like a one-stop. I couldn't do that in any event because of the nature of the charge, and it's a victim's rights case, so I'd have to have him evaluated on that. But have I complied with the court rule?
You have, Your Honor, as usual.
Yeah, right. Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation
Thank you, Your Honor.
for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. or
Judge.
light indicates. That's why we don't let her come. Go ahead. What?
I'm so sorry. I have a jury trial scheduled to start in Wayne County on November 10th, and it's a CSC case, so it's going to run through the 12th, I'm sure. So I'd ask for a different sentencing date, please.
In this live courtroom, a domestic violence plea stops cold on one question: was the touch intentional and without consent? Watch the judge drill down for clarity, then see rapid dismissals and a second offense OWVI plea where sobriety court could change a defendant's path.
You know, I almost want to say no.
Can I zoom in for sentencing?
No.
Okay.
No. We're going to make you come here.
Very well.
Can we?
December.
The 10th?
Yes.
10th is when the jury trial starts.
Can't
Oh,
do-
December
can't-
10th, you said? Oh, that's great. Perfect.
Sure.
Yes, Your Honor. Perfect.
Sentencing will be December, actually the 12th was perfect too, but you just messed that up. December 10th, 2025, 9 a.m. or as your invite indicates, bond with its conditions will continue. Thank you, sir.
Thank you so very much, Your Honor. Good to see you.
Take care. Court calls the case of the people versus James Baltes.
Ellen on behalf of the accused.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Baltas. State your name for the record, sir.
James Lee Baltus.
Thank you.
At this time, you are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right. Thank you, sir.
Thank you.
Court does call the case, people versus Jason Eckel.
The people.
Good morning, Your Honor. Robert Goldman, PA 1222, appearing on behalf of alongside defendant Jason Michael Eckel, president of the courtroom this morning. Mr. Eckel, would you please say your full name for the record?
Jason Michael Eckel. All right. The plea form that the court has in front of it is that the defendant is going to plead to an added count 2 of operating while visibly impaired to second offense. The 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing to enter and participate in sobriety court. Is there a particular sobriety court that he's going to be entering, or?
I'm not sure that he's been screened yet, Your Honor. Counsel and I had the chance to discuss this morning, and he let me know his client's interest in sobriety court. And given some of the facts and background here, I think that's a really good option.
Got it.
So I don't know that he's been screened.
Screened as, okay, but he does agree to do that. Is that correct, counsel?
Yes, Your Honor. And he is a resident of Ypsilanti. And so
You're not, right?
I'm not, no, Your Honor.
I could tell by the way you said Ypsilanti, but go ahead.
So we are open to a sobriety court that has room for admission. I do believe that he would qualify as a resident of Washtenaw County. And otherwise, we anticipate it to be a successful screening for admission.
Okay. And I mean, 14A has a.
I think that would be a good place to start is 14A.
Yeah. Okay. And that's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Accurate, Your Honor.
All right. May I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand and say your name.
Jason Eckel.
Say that again.
Jason Eckel.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 5 days to 1 year in jail, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
And understanding that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty of those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
Besides my wife, no.
All right. You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
All right. On September 4th, 2024, at the location of 3900 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, remember the questions we went through?
Yes. Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What you have and how much?
Mike's Hard Lemonade, about 3/4 of a tall boy.
Okay. Were you stopped by the police or was there an accident?
Your Honor, there was a welfare check was conducted. Officers responded by way of a dispatch for welfare. Mr. Eckel came into contact with officers in the parking lot of a Lowe's retailer in light of the welfare check response.
Got it. Okay.
No accident involved, Your Honor.
Okay. And ultimately, were you arrested?
Yes.
And were you taken to the hospital for a blood draw?
It's an intoxilizer case, Your Honor.
All right. And were the results of that intoxilizer 0.09 and 0.10?
Yes.
Do you have any reason to dispute those results? All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. And had you previously been convicted of operating while intoxicated on or about December 6, 2021 in the 14A3 District Court?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would no longer be bound by that. You understand that?
Yes, Your Honor.
You also understand that you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
All right. And has the court complied with the court rule? And would it be proper to accept this defendant's plea?
The people are satisfied.
So satisfied, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed.
1 docket, big stakes. The judge locks in consent and intent on a DV plea, reminds everyone about rights and consequences, dismisses cases the state can't try, and here's a repeat OWVI plea that may lead to sobriety court. Justice, accountability, and second chances, back to back.
Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be here on I'll set it for November 12th, 2025, 9 a.m. Bond will continue with its conditions. What I'm going to suggest to you, counsel, is to go down to probation at this point in time, indicate his interest in sobriety court, and see there are 2 probation officers working down there at this point, my probation, as well as the sobriety court probation person. So let them know that and let them direct you as to how he should proceed.
Will do, Your Honor. Thank you.
Thank you.
The courtroom's atmosphere turned palpably tense with the first case, a straightforward domestic violence plea that became a masterclass in judicial precision. The defendant admitted to touching the victim on the waist without her permission, but the judge, demonstrating that guilty pleas require unambiguous foundations, zeroed in on the critical element, intent. The exchange was halting and revealing. The defendant initially wavered, suggesting the touch might not have been intentional. The judge, with calm persistence, forced clarity. Did you intentionally touch her when you said you touched her on the waist? Finally, the defendant conceded, yes, you did. This established the necessary factual basis, intentional, non-consensual contact. Further probing into their relationship, with the defendant awkwardly clarifying they were dating but not boyfriend-girlfriend, added a layer of uncomfortable context. Having meticulously secured every element of the crime on the record, the judge accepted the guilty plea, ordering a pre-sentencing investigation and setting a sentencing date for November. This rigorous adherence to procedure, even in the face of a willing plea, underscored a fundamental principle: the court's record must be ironclad. The session then pivoted from the interpersonal violation of a DV case to a societal danger, with the case of Jason Echo pleading guilty to operating while visibly impaired, second offense. Echo admitted to drinking 3/4 of a tall boy of Mike's Hard Lemonade before a welfare check in a Lowe's parking lot, with a test result of .09 BAC and a prior OWI conviction from 2021. The standard penalties were laid out, but the plea agreement revealed a rehabilitative pathway. In a significant judicial decision, the case was steered toward sobriety court. The judge actively facilitated this, advising the defense to go down to probation, indicate his interest in sobriety court. This wasn't a passive acceptance of a deal, it was an active endorsement of a treatment-focused alternative to standard punishment. Sentencing was set for November, with bond continued, making his immediate task not jail time, but engagement with a specialized court designed to address the root cause of his offenses. The hearing presented 2 starkly different portraits of judicial intervention. For the domestic violence defendant, the intervention was a forensic dissection of his actions to ensure the plea was legally sound, protecting the integrity of the process. For the repeat OWI offender, the intervention was channeling the case toward a problem-solving court aimed at long-term behavioral change. One ruling was about meticulously establishing past wrongs, the other was about strategically structuring future correction. Both, however, shared the judge's commanding control over the narrative of the courtroom, demonstrating that justice is administered not just through verdicts, but through the precise questions that precede them and the tailored pathways that follow.